Hi, guys. Welcome back. This is Karina.
And this is Eric.
And this is the Late Podcast. Podcast, The Law According to Eric. All right. So last week we went over what bankruptcy was. And this week I think it's a good idea to speak on the steps to file bankruptcy to get on the road to a debt-free life. So after finding a good bankruptcy attorney, Eric, what comes next?
Well, if it's a good bankruptcy attorney, you're going to go through what's called an intake process.
Okay.
Intake essentially, number one, verify who they're speaking with is the actual person that's going to file. You'd be surprised how much bankruptcy fraud actually happens.
Mm-hmm.
Usually it's when there's a foreclosure looming. People get desperate, so they hire these like fly-by-night, like fraudulent bullshit companies that promise to get them out of foreclosure and modify their loans, all this kind of stuff. This was a very, very big problem back in like 2009 and 10 when we were going through like the essentially the aftermath of the mortgage meltdown.
Mm-hmm.
So number one, it's very important for the attorney to confirm the identity of the person filing.
Okay.
Then the attorney will go through a list of questions to essentially help him or her determine which chapter is the best chapter. Now, depending on certain things like the amount of secured debt that a person has, that may automatically dictate, right? They may have no other choice but to do Chapter 7 or Chapter 11, for example, and so on. But then they'll also go through like what their income is, how much, what their expense is. Do they owe child support or alimony? Do they own property? Do they own vehicles? Do they have back taxes? Do they have student loans? They go through the whole sort of gamut of background information, and then kind of help the client determine what the best chapter is, or even if bankruptcy is even for them.
Right. So what should they do to prepare for this? What do they need to bring, or what should be brought?
A good attorney will communicate that ahead of time, and like what we do here is we usually provide the client with a checklist of things, and depending on if it's a self-employed person or a wage earner, or if it's for a corporation or an LLC or some other business entity. But the list is often similar. You'll need to show the most recent filed tax returns. If you're self-employed, bank statements. If you're not self-employed, your pay stubs, copies of, for example, your mortgage statement or a copy of your lease, or copies of checks to your landlord, your car payment statements or lease statements, all that kind of stuff. So there's usually a checklist of the most important documents. Usually they're just ones that confirm the information given to the attorney, like the income and the expenses. And the other thing that's really important that I don't think a lot of people understand is that the attorney has to determine also, based on like the means test and federally what's allowable, like if the person's expenses are reasonable. I had cases in the past, like in Chapter 13, where we're showing like their expenses, and I've had judges. One judge in particular who now is no longer on the bench, but her name was Judge Ellen Carroll. She was in downtown Los Angeles. She would routinely force the attorneys to increase like plan payments to unsecured creditors by saying something like the amount that this person is paying for their cell service is too high.
Okay.
They shouldn't be paying more than $40 a month, and they're paying $150. So I'm going to take this $90 difference or this $110 difference, and you're going to add that to your monthly payment to the unsecured creditors. That's a bit of an extreme example, but that happens. You're supposed to show what your expenses are, and they're reasonable, right? So you can't claim that you pay $500 a month, say, for cable and internet.
Right.
That's going to be, considered fraudulent or heavily scrutinized at least. So that's what really should be the next step. You go through the intake.
Okay. And then after the intake,
once the attorney and the client agree on what the goal is and what chapter is best suited to meet those goals, then the process of filling out or completing what are called the schedules is the next step. So we use a particular software called Best Case that kind of helps us put all that together. Best Case also has a module where we can pull a credit report with the client's authorization. Best Case helps fill in the amounts of the monies owed based on that credit report. It's all kind of integrated. Best Case also keeps up with changes in the means test and other things and helps us kind of calculate. But I should say, and this is with a very big caveat, most attorneys, if not all, should not rely 100% on their software. Every client case is going to be different.
Right.
Yeah, there may be an instance where some expenses seem really high, but you have to take into account where they live, how long they've been there, if it's a lease, what was their financial position before they entered into that agreement or purchased that property or what have you, right? I have a client today who is a Chapter 7 bankrupt, essentially lost everything. He has a home. There's really very little equity in the home, but it's like a $7 million house, and the payments are $18,000 or something a month.
Mm-hmm.
Well, that seems so high, and that's exorbitant, but that's what his mortgage was. And at the time they bought the house, he could afford that.
Mm-hmm.
So again, it's all relative. So,
right.
but use of bankruptcy software really does help at least give you a preliminary picture of if this person is going to qualify for this chapter and
of course.
what some red flags might be, things like that.
All right. So I wanted to touch on 2 questions that I saw that could be important for us to talk on. So before we start the first question, do you want to explain what automatic stay is before I get into this question?
Okay, that's a good one. So I believe, just by the way, for our 9 listeners, I'm doing this without looking at any manual or anything. I think it is section 362 of the Bankruptcy Code that spells out the automatic stay. So the first part about that term, the 2 words, automatic stay,
mm-hmm.
the first word automatic means exactly that.
Right.
The very second a bankruptcy case is filed and a case number is assigned, the automatic stay goes into effect. That automatic stay initially is absolute, barring some very specific exceptions, which I'll tell you about in a minute.
Okay.
That automatic stay essentially freezes all actions against what we call the debtor or the person filing. Legal actions, lawsuits, collection activity, wage garnishments, phone calls from collection agencies, bills that come in the mail, like nasty billings, everything stops. And if a creditor knowingly violates the automatic stay, that can be a big problem for the creditor.
Okay.
If the court determines it's a willful violation, they will be liable not only for the actual attorney's fees incurred by the debtor, but could be liable for punitive damages just for doing that. So it's a very, very serious, very important component of bankruptcy. There are some exceptions.
Okay.
Usually they deal with multiple bankruptcy filings, one after the other. Mm-hmm. And so when it's looked upon like abusive, then the automatic stay is not absolute. If more than one case has been filed within a year, you have to file a special motion and have that motion heard within the first 30 days of a case, asking the court to basically extend the automatic stay, because it's only good for 30 days in that instance, right? The first 30 days. And absent a court order, it terminates at the end of 30 days. There are other examples where there is no automatic stay, depending on how many prior filings and some other things like that too.
Right.
Generally, it's automatic and it's absolute.
Right. And you answered the question as well, because the question was, when does it start? And you answered in the beginning. So
all right, there we go.
Got through that question. So the next one, it was, when taking the means test and claiming my overall debt, do you include all interest of all the overall loans, or is just the principal that's accounted for?
You include, well, first of all, the means test has nothing to do with the amount of your debt.
Okay.
The means test is really based on your income and whether your income falls into this national average,
mm-hmm.
and then depends on your expenses and whether you have any leftover or disposable income at the end. But the means test is essentially set up so that you get an idea, sort of a baseline of how much money you can make and still qualify for Chapter 7 without having to pay anything back. And then you can overcome what's called a presumption of abuse. If you earn more than what the means test says your maximum should be, let's say for a family of 4, right? Then the means test is you should earn X per year. And if you earn less than that, X or less, mm-hmm. you're good. If you earn more, then that's called a presumption of abuse, but you can overcome that presumption mm-hmm. by showing that you have these valid expenses and that, this is it. Mm-hmm. So the means test doesn't have anything to do with the debt part of it.
Okay.
But to answer that question, like how do you schedule that debt? Mm-hmm. It's the amount that's owed around or as of the day you file.
Okay.
So if I have a credit card mm-hmm. and it charges me 19% interest, whatever my most recent credit card statement shows, and mm-hmm. it usually shows the total due and then what your payments are, that's what you schedule. If you have a car loan, right, you just schedule the amount on your last statement, the most recent statement. That's it. Interest stops accruing usually right at the onset of the filing, unless it's like secured, right? So like a car loan might be a better example of that, where your interest continues to run, assuming you keep the vehicle, right? So that's the more important part of this. If I'm going to keep my car or a house, then the interest continues, but I also have to make my payments, like current.
Right.
In a Chapter 13, I can repay the missed payments. There's some debate because if I include, let's say I'm 10 payments behind on my house. If my payment includes principal and interest and taxes, like everything, then in theory, that should be all I'm supposed to make up.
Right.
Some are interest only. They don't include property taxes and insurance. Some lenders will try to add like default interest on top. And again, it's a case-by-case basis. You can object to it if it's filed as part of a claim. I mean, it gets kind of complicated, but the basic answer is you just schedule the amount on the last credit card or mortgage or car loan statement or whatever it is, student loan statement, as of the day you file.
Okay. All right. So for our last question that I have, just as the main questions we're answering today, I saw a lot of people asking when they come in and like they meet with the attorney or the paralegal, if they should bring up that they have a lower income, that's why it affected their ability to keep up with their payments. I feel like we should know that, but a lot of people wonder if that makes a difference or if that affects it at all.
I don't think it matters unless it ties into whether or not the debt is dischargeable. I know that's a little complicated, but let me respond by giving you sort of an example, a real life example. I had somebody come in to consult with me about 5 or 6 years ago who wanted to file Chapter 7. They said they've got $85,000 in credit card debt. Okay. So when I asked the person, are they currently employed? They responded that yes, they were. And then I asked them if what they did for a living and how much they earned, and essentially it came out that they worked at a car wash and they made $17 an hour. Okay. Well, so then my next logical question is, well, is that what you do now, or is that what you've always been doing? Right. And the answer was that's what they've always been doing. Okay. So the next logical question is, well, how were you able to obtain $80-some thousand in credit based on that income? And the reason I asked that, and why most attorneys will ask, is because we want to make sure that those debts weren't incurred by fraudulent means. Right. So if that person filled out a credit application and said that they make $80,000 a year instead of $30,000 a year, and the bank extended credit or the credit card company based on that proposition or based on that information, that could be considered fraudulent. Right. So you don't necessarily have to ask like, well, what happened that you couldn't pay your bills? But I do think it's important to know if they're employed, where they're employed, how much they earn. For the means test purposes, but for general informational purposes, most people, they fall into one of three categories, assuming there's no fraud or funny business. Either they've lost their job, or they went through a period where they got laid off. Maybe they found new work, but they make less now, or they fell so far behind that they can't possibly catch up. Sometimes it's because of a medical issue, right? They got sick, or they had surgery, they got laid off, or they had to go on disability. So now their income went from X to Y, and Y is super low. Or they're going through some kind of life event. Like they lost their partner, they had a death in the family, or they're divorcing or something like that. And then their income could change based on, for example, in a divorce, if I make $150,000 a year, but I'm ordered to pay $100 a year in support, well, I still make $150 a year, but I've got this monstrous expense, right? That kind of thing. So the reason somebody stops paying really only becomes important if it's fraudulent. Oh, that's another one too. Sorry, not to, I could do this all day. But there is something in the law that is a little obscure but important. That's called first payment default. And there is a presumption of fraud if an individual obtains a loan or some type of credit, utilizes that loan or the credit card, and then doesn't make even their first payment. Right? So first payment defaults are also considered fraudulent. That's something that we would ask when we're going through the intake. I look at the debt. Okay, how long have you had this, for example, credit card? When was the last payment you made? And I want to make sure that for two reasons. One, I want to make sure that they've made at least those initial payments when they first got it. And two, I want to make sure they're not paying it now. Right? If they're going to go bankrupt, stop paying it. Right? Now, and people, by the way, that's another thing. Sorry, I don't mean to go down this rabbit hole, but please, for the love of everything sacred to everybody that's listening, if you're going to file bankruptcy, do not bang up your credit cards and max them out and buy a bunch of stuff right before you file. That is a huge like red flag for fraud. And I've had people, God love them, I've clients bought like jewelry and electronics, like a big screen, like a flat screen TV and all that stuff, and then wanted to file like a week later.
Yeah.
That's a no-no. If you used your credit cards very shortly before you filed, but you use them for things that are considered necessities of life, food, gasoline, you paid your utility bill, that's usually forgiven. That's kind of like looked past.
Mm-hmm.
But if you banged up your credit card and you bought jewelry and clothing and appliances or whatever, that's a problem.
So let's say they did do that and then they tried to file bankruptcy. Will it just not be filed, or?
Well, I hate to say this. There's probably a lawyer that will do it.
Okay.
I'm not that guy. But I would say the lawyer has to, at the very least, give a full disclosure to the client that they could be, facing some potential liability.
Right.
They could be responsible to repay those last charges.
Okay.
And that would be getting off light.
Yeah.
The U.S. Trustee's Office could seek a determination to basically prevent them from getting a discharge of any debt.
Right.
They could refer it up as a criminal matter to the DOJ, because what people don't realize is the Office of the United States Trustee,
mm-hmm.
they oversee all bankruptcies and bankruptcy courts and the bankruptcy trustees and all that stuff. That's part of the U.S. DOJ.
Right.
So you take a big risk if you take your Visa and your MasterCard and you buy a bunch of expensive bougie nonsense and then try to file bankruptcy right away.
Yeah. All right. So is there anything else you'd like to add before we start our next segment?
Yes, I do. I want to give a little shout out to a local establishment named Insomnia Cookies. They got this deal now till the end of October. It's only a few more days.
This is not sponsored and it's not an ad.
Thank you. Fair enough. But they just bake these cookies on the spot. And now they've got a thing for like 20 cookies for $20. And they're just so outrageously good. So we enjoy our Insomnia Cookies snack while we record. So just want to let everybody know those are pretty amazing cookies.
Thank you for putting everybody onto that.
All right.
All right. So let's start the next one. And this is our What Would Eric Do? Our Reddit segment. Okay. So in light that it is spooky season and Halloween is coming up and all things scary, we'll talk about bankruptcy and divorce.
Those are two very scary things.
All right, let's get started. The first one is actually titled Bankruptcy and Divorce.
Oh, okay.
I know someone who's been divorced for over 10 years. This person has filed for bankruptcy, but the problem is one of their cards is in both her and her ex-husband's name. Before anyone says it, yes, I don't know why neither of them have called in and removed the other from the card in all these years. Well, there's the thing. The ex-husband is now demanding that she makes a payment through their 30-year-old son, who is now in the middle of this whole thing. So here's the question. Is there any legal way to get the husband removed from the card before the lawyer files the bankruptcy?
That's a poorly worded question. So I'm going to answer it based on what I think they mean. Okay. First, it matters if this credit card was joint or if one was an authorized user for the other.
Right.
Okay. So I can tell you that I have an American Express where I add users if I need to,
mm-hmm.
right? But I'm solely responsible.
Right.
Okay. So an authorized user is not the same thing. They're not liable for any charges.
Mm-hmm.
If it's joint, then both parties could conceivably be liable for the charges made on the card.
Okay.
Now, having been divorced for 10 years, it should be in the divorce decree who's liable for what debt.
Right.
I'm guessing, though, that credit card debt 10 years ago has been recycled a million times.
Right.
Right. So I don't know. Otherwise, so whoever initially got the card probably should be the one to contact the lender and say, I need to remove this person.
Right.
Or that person can jointly file something to get removed. There's nothing the court can really do unless it's like an order, but I don't know that they can do that because these third-party contracts, which
mm-hmm.
is basically what this is, right? So the credit card company is not a party to their divorce.
Right.
So if husband and wife divorce and they have in their divorce agreement that you pay X and I pay Y, the lenders of the credit card company, they're not a part of that. They don't care.
Yeah.
Right? You both signed. I don't care. One of you pay me. I don't care what you two decide.
Mm-hmm.
So I can tell you practically, assuming this is a case in Los Angeles or somewhere in California,
mm-hmm.
normally what will happen is the credit card company will either go after the non-filing spouse or they'll just close the whole account.
Yeah.
and they'll take the loss because it's going to get discharged unless it's fraudulent. It'll get discharged anyway.
Right.
Right. There is something else called a co-debtor stay, but they're divorced, so that really won't apply. But that's what I think. It's kind of foolish that it went 10 years and not one of them.
Yeah.
And if they keep using it. Oh, sorry. To answer the other more like ridiculous part of the question, no, don't make your son make a payment for you. Okay. If you're filing bankruptcy anyway, we just talked about it. Don't pay. It's going to hurt the other person's credit maybe. That sucks. That other person should try to get the card canceled or out of their name. That's it. Don't pay it off. It's going to be considered like a preferential payment because that's an unsecured creditor that's getting paid before everybody else is. And this creates a can of worms for your bankruptcy attorney.
All right. Next one. This one's called divorce and bankruptcy. After getting divorced and having a divorce paper say my ex-husband owed me some money, ordered by a judge, he filed a Chapter 7 bankruptcy and it was granted. I only got a notice saying it was granted, but it didn't say if he would still be responsible for paying me or not. As I read that sometimes, even when bankruptcy is granted, they still need to pay some debts, like the ones ordered previously by a judge. Could someone please give me info on this?
Yes. I'm going to try my best, but this is a disclaimer that please don't take this as legal advice, and I don't know what state you're in. Generally speaking, things that are considered to be domestic support obligations, which is alimony, child support, are not dischargeable in bankruptcy. They will continue to have to pay those support payments or the arrears, or if they give it to the DA to collect for them, the DA will file a claim, what have you. They should file a proof of claim in that Chapter 7 if it's not too late to do that. They could try to seek what's called a determination of non-dischargeability from the court. But generally speaking, domestic support obligations, so unpaid child support, back child support, unpaid or back alimony, are not dischargeable in bankruptcy. You still got to pay that.
All right. Next one, breakup bankruptcy threat. I'm a 22-year-old female, and I'm recently going through a breakup with my 22-year-old male boyfriend of 6 years. We bought a house together, and I co-signed.
Wait. Sorry, hold on.
I wish you could see his face.
What's 22 minus 6? 12?
I'm not good at math, Eric.
16.
16.
Sorry, yeah. No, I should get better at math.
That boy math.
Oh, yeah.
Yeah, I'm only good at girl math, but yeah, 16.
Sorry. By the way, to our 7 listeners, that background voice, that's Jennifer, our bookkeeper, and my number one special someone. So
there you go.
Might as well just say hi now.
Yeah, hi, Jennifer.
Hi, yeah.
Okay, there you go.
All right.
So, all right. So let me put aside the creepiness of the 16-year-olds. All right, go ahead. Sorry.
All right.
Sorry, continue.
So they bought a house together, and she co-signed his car for him a few years back. He still swings by the house because they split times with their dogs, and he still uses the kitchen because he's moved in with his parents and he doesn't have space. The problem is that now that we are no longer together, he has been an absolute nightmare, and he keeps threatening to file bankruptcy just to F me over because he already has bad credit. So it won't affect him at all. My question is, what can I do about getting my name off of that car? It's not paid off yet, and he would have to refinance it, but is there a way to get off the title without his permission, or do we both have to agree to get my name off of it?
You probably will both have to agree. You can petition the state court, so this is not a bankruptcy court issue, and ask for some kind of declaratory relief, but that's going to fail. And the reason is because when the vehicle lender extended credit, they likely did so based on both parties guaranteeing their loan. And ultimately, the one that gets, quote, fucked over is the lender. If you guys are allowed to do that and pick and choose, well, no, I want off the loan now. It's his problem. But, and by the way, he's the real deadbeat. I'm not.
Right.
No. So probably not. The bigger concern, to be frank, first, if they're current on the vehicle, even if he files bankruptcy, he can reaffirm it and make the payments.
Right.
Okay. The bigger problem is this house.
Yeah.
Right? If the house is in both their names, and if there's equity, and the equity exceeds the amount of the homestead exemption, that house could get sold.
Yeah.
By a bankruptcy trustee. So if he's threatening to file bankruptcy for all that, that's a bigger problem. I'm not sure what state they're in, and if it's any. I mean, I don't know if they're. I see. It doesn't seem like they're married. No. Right. So it's not. So the community property aspect wouldn't matter necessarily, but I don't know. That's a tough one.
She also shouldn't let him in the house anymore. They broke up.
Well, okay. But it's half his, right?
Oh yeah, I guess, and their dogs. They split time. That's why he comes, because he splits time with their dogs.
Yeah, something tells me that's just the excuse to mess with her, whatever. But okay, that's a question I don't know that I can really give a good answer for.
Yeah.
I just don't think there's a good way around it.
Mm-hmm.
Actually, the best advice, honestly, is if he would be willing and she, they should go to like a small private mediator to try to work out almost like a division of property like you would do in a divorce.
Mm-hmm.
Because even though they're not married, they have shared assets.
Right.
And I guess they consider the dogs like children and they visit. They should probably try to do some kind of, for lack of a better word, settlement and custody agreement for that. Maybe if he shows up every so often on certain days, he can play with the dogs and cook himself breakfast or whatever, and she can leave for an hour or two. I don't know. That's what I might consider trying.
Yeah.
For somebody in that kind of situation.
All right. Next one is called X is filing Chapter 7 bankruptcy. He's behind in support, but he doesn't have me listed as a creditor. My ex-husband is filing Chapter 7 bankruptcy. He currently owes me over $200 in unpaid rent. We co-own a condo he lives in, and child support. He did not list me as a creditor in his bankruptcy, and I've been trying to work with him on his past due support to me, but it's just been a bit sporadic. In early 2022, before he filed bankruptcy, I even suggested that we sell the condo and he could use his half of the equity to pay off his other debts. No, I am all for selling the condo, as I also had debts that have accrued over the year. He did not pay me. He told me that he did not want to sell the condo until after he declared bankruptcy. I am unsure why he didn't list me as a creditor in his bankruptcy, as both he and his lawyer know that he owes me money. I'm trying to understand why he may have done this, and if I need to do anything to protect myself and my child.
Okay, well, I don't think the child's in danger. Start with that. I know, mama bears come out, but okay. First, she can, at least here in California, in the Central District, you can file a proof of claim in anyone's bankruptcy, and you can do it online through the court's website. So that's the first thing I would do, is find out where he filed and what the bankruptcy court is in that local area. It's based on zip code. And see if on that bankruptcy court's division's website, she can just file a proof of claim.
Okay.
That's the easiest way.
Yeah.
If he unintentionally omitted her as a creditor, or even intentionally did, it may not matter if it's what we call a no asset case.
Okay.
So they may have equity in their condo, but if the equity is not more than what their exemption would be, then it won't be liquidated or sold, and they can keep it. That's also probably why he wants to wait until after, so he can wipe out all the other debt that he can,
right?
Then sell it, and he'll get to keep the bulk of the equity. If they are divorced and no longer married, but they qualify both equity-wise and means test-wise, she might consider doing her own Chapter 7.
Okay.
Wipe out her debt too, that's accrued over the years. Again, the child support and the spousal support or whatever, I guess they weren't married, so just the child support, that cannot be discharged.
Right.
So she should file a proof of claim for that anyway, just in case there's a disbursement or distribution of some kind. But otherwise, it won't matter if there's no distribution from a trustee. It's not going to go to her anyway.
What about the rent?
The rent, she can add that it would be like an unsecured debt.
Okay.
It's not enough to, I think, raise red flags with a bankruptcy trustee.
Right.
If I were a trustee and the amount were more, like someone said, oh, he owes me $25,000 in back rent for the last 2 years, my thought would be, well, if she's a co-owner, she's getting the benefit of adding and building the equity by covering it, and then I'd also need to know if there was a rental agreement between the two or some kind of contract.
Right.
It's probably not enough just to say he owes me rent or he rents back from me, even though we split up.
Right.
It doesn't make sense because he's a joint owner, right? So he's not really renting; he's just living where he's supposed to live.
Yeah.
Maybe they made that part of whatever support he gives her or something, and that's what they call it. I don't know. I'm gonna tell you.
All right. Next one. Going through a divorce, my wife makes 2 times more than me, and she won't accept any debt and says that she's going to file for bankruptcy. All right. So that was the title.
Oh, sorry.
All right.
Read it again. All right, my bad.
Going through a divorce, wife makes 2 times more than me, won't accept any debt, and says she's going to file for bankruptcy.
Well, okay, so I don't know that there's a question there.
No, the question is keeps going.
What should I do?
No, hold on. It gets better.
Okay.
I found out my wife was cheating on me, and then she filed for a divorce. We have a modest debt of about $20,000, a car, and a mortgage. She makes about $4K a month and I make about $2K. Right now, I have the car and she has the house and most of our stuff. I have our car and a few furnishings and she has been paying our mortgage and I've been paying the car. We've been splitting the debt payments in half, about $450 a month. Debt is in both of our names. She is saying now that she is going to file for bankruptcy and then sell the house after and keep her money. We talked to an attorney and he said that they'd come after me for the debt unless I filed for bankruptcy as well, which I would rather not. Is there any way I can prevent her from defaulting or file a bankruptcy?
No, you can't force somebody not to file.
Okay.
And if they choose not to make the payments, that's what they choose. He's in a bit of a pickle because that's true. If he is jointly liable for the debt, and that's why banks have co-signers for exactly this reason. I don't know how much equity they have. I don't know if where they live, the means test for their area is greater or lesser, right? So she may not be able to do a Chapter 7. She may have to do a Chapter 13, which will allow some repayment. But yeah, there's just there's no good answer for this guy.
Yeah.
Try reasoning. I don't know. What can I tell you? Good luck with that. But
he already had bad luck.
Yeah.
She was cheating on him and divorced him.
Yeah, by the way, this might be a question that people come up with. Getting cheated on isn't grounds to force somebody into bankruptcy. and getting cheated on doesn't change the answer.
Yep.
Other than, you were married a whore or whatever. But besides that, it doesn't change the analysis. Just putting that out there, okay?
Yeah.
Bad decisions are made, but that doesn't change the legal analysis of anything.
All right, our last story. And this lady spilled the tea, as I heard Eric using earlier this morning. So be prepared.
Oh, okay.
All right, this one's called Bankruptcy or Voluntary Possession. Her husband and her are divorcing, and within a few weeks, it'll be final. All debts are in her name, and she recently had to purchase new vehicles for both of them because the ones she had were unable to be driven. So they owed $4K on his car and $14K on hers. So she did the stupidest thing that's her words, not mine, that she could have done financially, and she let the dealership screw her over. She said, I owe $62K on a truck worth $35K and $34K on a car that's maybe half that. Plus, she has $17K on a consolidated loan.
All right, let me make this easy. I don't even need to hear anymore. Bankruptcy, and then you can do what's called a surrender of the vehicle. So there is something called a statement of intentions that you fill out and file as part of your bankruptcy schedules. That deals with secured debt like a mortgage or a car loan. If you want to keep your vehicle and you're current, you can file Chapter 7. You can still keep your car. You do what's called a reaffirmation agreement, or you just stay current, right? The other option is you can put in your statement of intentions, I intend to surrender this and give it back. I would never in a million years, I'm going to give you two important reasons, sorry. I would never in a million years advise a client to keep vehicles that are that upside down for any reason, okay? I don't care how much you like anything, that's ridiculous, number one. Number two, most people don't realize filing Chapter 7 especially, you meaning the person that files, will start getting new credit offers like within 3 months, including pre-approved car loans. Because when you file Chapter 7, generally speaking, there's always an exception, but generally speaking, you wipe out all your unsecured debt. You're not the big credit risk you used to be because you don't have to pay anybody else.
And her credit's not bad. She included her credit score, 730.
Yeah, that's all I'm saying. But no, after bankruptcy, it'll go down and it'll start to come back up. But the point is that there are lenders that will take a risk on you again right after bankruptcy because you don't have to balance 50 payments for all these different things. You just have to now pay the one new loan, and you cannot file bankruptcy again for 7 years, a Chapter 7. So they're at a much lower risk. They can always repossess the car if you stop paying it anyway. So if I were this person, I would surrender those vehicles through the bankruptcy. Don't voluntarily surrender. It's like a repo. Credit's going to get screwed up anyway. You're better off BKing, get rid of all the debt, including the car loans, and start fresh.
All right. And that counts with the divorce as well. There won't be an issue with that.
Well, I don't know. It says it'll be final in a few weeks, but she bought a car for him too. That's a pretty nice ex.
Yeah. Well, I think that was before. She claims here that she had only done it because he had been doing really well, or so she thought, because I guess he had a job, but right after she got that, he quit his job and then got back on drugs, she said.
Oh, I guess we didn't read all of it.
No, we didn't read all of it, but yeah.
Okay. All right. Well, I would say then tough luck on him.
Yeah.
If she's the owner, technically, it's in her name, it's her right. If he wants to reaffirm it and pay for it, that's up to him. But it sounds like a lot smarter
Yeah.
to just surrender those upside down, no equity vehicles that you're just going to overpay for forever and start fresh. By the way, I don't know if it says it, but it sounds like they're like from Texas or something.
She didn't mention no.
It just feels like they get like big oversized trucks.
Yeah.
That aren't worth a lot, but they just overpay because they have like the gun racks and you can drink beer in an open container in Texas. That kind of stuff. But anyway.
So she did.
Sorry, because everything's bigger from Texas, right?
Yeah.
Including the purchase prices and loans, I guess.
She did say the consolidation loan that he has been ordered to help pay with her, but she believes he never will.
Again, the lender's not a party to their agreement or their divorce agreement, if that's what's indicated there. She's better off to just wipe it out. If he signed with her on that consolidation loan, then they can go after him. If she just took it out and helped him, then she should bankrupt it. I don't care what he promises. Even if he's a great guy and not on drugs and all that stuff, why would you risk the exposure of being stuck with this loan in the event he does default? Again, even if he's got the best of intentions.
Right.
He relapses, he loses another job, something. You never know. Just get rid of it.
All right. Well, that ends all of our stories. So would you like to add anything at the end?
Just that this is, again, is a work in progress. Our first episode, I don't think came out as well as we had liked. So we're trying a few different things as far as like proximity to the microphone and all that. And, keep listening, keep sharing. Follow us on all of our social media. Karina's going to give you the breakdown. Which client is it that always misstates your name?
Don.
Oh, yeah.
Katrina. He calls me Katrina. Yep.
So that's from now on, by the way, we're going to call you the Hurricane.
Is that how you feel when I walk in the office?
I'll tell you, if anybody gets to meet you, they'll understand Hurricane Katrina's real. That's just not in the South. That's,
All right. Well, our Instagram is at the Bensama Confirm. Our Twitter is at Bensama Confirm. Our TikTok is at Bensama Confirm. And then our website is eblawfirm.us. And then you can email us at info@eblawfirm.us.
Really quick, are there any cookies left?
Yeah, there's a lot actually.
All right.
Jennifer only brought one for her when she came in. She didn't bring any for us.
And fast on Jennifer.
All right. Bye, guys. Thank you for listening.
Till next week.